So, the Supreme Court heard arguments yesterday on the January 6th protest. Specifically, the justices were honing in on the statute 18 U.S.C. 1512, subsection C2, which deals with obstructing, influencing, or impeding any official proceeding or attempting to do so with felony obstruction. However, the hearing that took place yesterday with the Supreme Court for 90 minutes didn't go the way that the feds nor the left-wing media had hoped for. Instead, what happened yesterday at the Supreme Court brought panic that those evil J6 protesters might just get away with being treated like, all the other protesters of the past, such as the hate riots from Antifa and BLM, who mostly received only slaps on the wrist, if anything at all. So to highlight this, let's take a look at the ultra-far left-wing news site known as Vox, who posted an article titled "January 6 Insurrectionists Had a Great Day in the Supreme Court." Vox wrote, "The Supreme Court spent about an hour and a half on Tuesday morning, arguing over whether to make it much harder for the Justice Department to prosecute hundreds of people who joined the January 6, 2021 attack on the U.S. Capitol. It appears after Tuesday's arguments," writes Vox, "that a majority of the justices will side with the insurrectionists, though it is far from clear how those justices will justify such an outcome. According to the Justice Department, more than 1,265 people have been arrested for playing some role in the attack on the Capitol. Approximately 330 of them have been charged under the Obstruction Statute at issue in Fischer, and one of them is Donald Trump." This, by the way, is the real reason why the mainstream media cares so much about this case. I don't think they really care about the J6 protesters so much as more of a way to get Trump, get Trump, get Trump. Anyway, let's continue with Vox's article. As the federal appeals court held in its decision in this case, the obstruction statute is pretty darn clear, says Vox, that it applies to an effort to obstruct any congressional proceeding intended to certify the result of a presidential election, like the proceeding that the January 6 rioters attacked. And very few of the justices seem to agree with Jeffrey Green, the lawyer representing a January 6 defendant, who proposed one way to read the statute more narrowly. Nevertheless, many of the justices expressed concerns that the law sweeps too broadly and that it must be narrowed to prevent people who engage in relatively benign activity from being prosecuted. Justice Samuel Alito, for example, expressed uncharacteristic sympathy for hecklers who interrupt a Supreme Court hearing, suggesting that prosecuting them under a statute that can carry a 20-year sentence goes too far. Justice Neil Gorsuch expressed similar concerns about prosecuting someone who peacefully conducts a sit-in to delay a court hearing, or someone who pulls a fire alarm to disrupt an official proceeding. This, of course, is referring to our good friend in Congress, Representative Jamal Bowman, a Democrat from New York, who pulled a fire alarm in a House office building to obstruct the proceeding. You see, there had been a heated debate over government funding as lawmakers were scrambling to pass the bill before the government shutdown. Bowman, after pulling the fire alarm and getting caught for it because, there happened to be video of this, pretended to just be stupid, saying that pulling the fire alarm was an accident and that he did not intend to obstruct an official proceeding. Of course not, right? Let's take a look at the video of Mr. Bowman accidentally pulling the fire alarm and see for ourselves, shall we? Now, I don't know about you all, but I've walked by thousands of fire alarms in my lifetime. And I don't think I've ever accidentally pulled a fire alarm that I can think of. Now, maybe I'm just lucky, but who knows? So anyway, what do you suppose his punishment was? Well, according to an article by CBS News, Democrat Representative Jamal Bowman pleaded guilty to a misdemeanor charge for falsely pulling a fire alarm in a Capitol Hill office building before a last-minute vote to fund the government in September. Bowman will pay a $1,000 fine and serve 3 months of probation, after which the false fire alarm charge is expected to be dismissed from his record under an agreement with prosecutors. How convenient. Bowman told reporters that he would pay the fine and the charges could be dropped after 3 months if he abides by the conditions of his probation. He called the incident a lapse in judgment. Okay. Anyway, let's go back to the Vox article. They would go on to say that Any optimism that the Justice Department might have had early on in the argument must have been shattered almost as soon as Prologer began her argument. Most of the justices peppered her with skeptical questions, although the justices who seemed to want to limit the obstruction statute struggled to agree on a single legal theory that would allow them to do so. And so Vox would go on to write that the bottom line here is that this case is probably going to end well for many January 6 defendants, but it is far from clear how the court will justify such an outcome. They write, the obstruction statute's plain text clearly applies to January 6 defendants, but it is unlikely that that's going to matter. Yet, while it is hard to read the obstruction law in a way that doesn't apply to rioters who invaded a government building for the purpose of disrupting the election certification process, forcing the entire Congress to flee for safety, many of the justices were concerned with other hypothetical cases where this law might be used to target less troubling activity. As Alito put it at one point, what happened on January 6th was very, very serious, but we need to figure out the outer reaches of the statute. Let's talk about that. Let's go back to the original intent and legislative history. I want to talk specifically about subsection C. So this subsection makes it a crime to corruptly alter, destroy, mutilate, or conceal a record, document, or other object, or attempt to do so with the intent to impair the object's integrity or availability for use in an official proceeding. It also covers otherwise obstructing, influencing, or impeding any official proceeding or attempting to do so. Now, the origin of this law goes back to Enron. The Enron scandal was all about widespread accounting fraud and corporate misconduct at Enron Corporation. The scandal involved the use of complex financial structures and an accounting loopholes to hide billions of dollars in debt from failed deals and projects and to inflate the company's profits and stock price. Now, in response to this, because this was a big deal at the time, this new statute was enacted to address this problem. The point of this law was to address the destruction of incriminating documents that Enron pulled off. This original purpose was all about combating white-collar crimes. It's all about evidence tampering, rather than prosecuting individuals involved in protests or riots. And that's why the focus is all about narrow scope of corruptly. Many experts here are contending that the term corruptly in the statute implies a specific intent to subvert or undermine the integrity of an official proceeding through dishonest means. This interpretation suggests that the statute was not ever intended to cover acts of protest, even if they disrupt official proceedings. Instead, the argument here is this, that the law was intended to focus on evidence tampering. Examples of this would be shredding documents. If you take this interpretation into account, it would suggest that the statute could not and should not apply to the actions of the January 6 protesters, who did not engage in traditional forms of evidence tampering. For example, the protesters did not alter, destroy, or conceal documents or other physical evidence that could directly impact the certification process, which takes us to the next concern here that Vox doesn't want to take into account, which is the overextension of legal boundaries. It is safe to say that the federal government used the statute and applied it to the actions of the January 6 protesters in a way that was overreaching. It opened the door to turn the law, which was meant for specific criminal acts, and turned it into a catch-all provision that could unjustly encompass a wide range of activities, including nonviolent protests. This could also potentially infringe on the First Amendment, and believe you me, our current federal government, as it is constituted now, would love nothing more than to crush anyone who disagrees with their growing Orwellian control of the population. But Vox doesn't see that, do they? Now, Vox would go on to bemoan that Prologer faced a blizzard of hypothetical applications of the obstruction statutes, along with vague allegations, as they put it, that the government was applying the law selectively to pro-Trump rioters. Justice Clarence Thomas, for example, asked her if this law had ever been applied to a violent protest in the past, where Prologer conceded that it had not, but attributed it to the fact that the January 6th attack was unprecedented. I mean, this was nothing compared to the billions of dollars lost thanks to the massive riots and protests from the hate groups Antifa and BLM. How convenient. Anyway, Vox would go on to say that there are several potential ways out of this trap. Prologer pointed out that the statute prohibits behavior that obstructs a proceeding, and a minimal disruption might not rise to that level, though that theory did little to quiet the many skeptical questions she received. Now, one of the appellate judges, writes Vox, who heard this case, Trump-appointed Judge Justin Walker, also suggested another way to limit the law. Walker homed in on the fact that the statute only applies to someone who corruptly obstructs a proceeding, and he wrote in an opinion that his word should be read to only apply to defendants who acted, quote, with an intent to procure an unlawful benefit either for himself or for some other person. Now, that interpretation, which Sotomayor and Kavanaugh both alluded to during Tuesday's argument, would allow the January 6 insurrectionists to be prosecuted. Because the whole point of the insurrection, claims Vox, was to procure an unlawful benefit for Donald Trump, a second presidential term. But it would prevent the obstruction statute from being applied to minor heckling and the like. Now, Vox would continue to write that among the court's Republican appointees, Justice Amy Coney Barrett seemed the least sympathetic to the insurrectionists. Still, writes Vox, even if the court's 3 Democrats hang together and even if Barrett joins them, it is unclear whether they can find a 5th vote to hold the January 6 insurrectionists accountable under this particular statute. So let's step back and look at where all of this stands right now. As mentioned by Vox, the liberal justices' stance is quite simple. They seem to be supporting the Justice Department's argument that the federal obstruction law is sufficiently broad to encompass the actions of the January 6 protesters. But the conservative justices showed a lot of skepticism. It would be safe to say that the majority of the court here expressed doubts about the application of the obstruction charge against the January 6 protesters. The conservative justices' concerns seems to suggest that they might lean towards narrowing the law's application, which from a non-emotional point of view would make sense. The law targeting Enron's behavior with their massive accounting fraud and corporate misconduct that led to its collapse was designed to strengthen financial reporting standards and increase accountability for corporate executives and auditors. The act was aimed to protect investors from fraudulent accounting activities and restore confidence in the U.S.'s financial markets. The last thing on the minds of those who created this law would have been a protest like what we saw on January 6th, which brings about no end to the frustration for the media here. They're all about viewing this in a traumatic way, while the arguments taking place in the courts was all about the technical argument. So what do I mean by that? Well, the oral arguments focused on the technical aspects of the 2002 law. They were focusing on what was its purpose, criminalizing actions intended to obstruct or impede an official proceeding through corrupt means, which involved the destruction of records. Anyway, the other complaint that most of the mainstream media has had about this hearing was the whataboutism from the conservative justices. During the arguments, the conservative justices, you see, engaged in what is being called whataboutism by bringing up left-wing protests, such as the disruptions at the Golden Gate Bridge, to question the consistency of the law's application across different types of protests, which I think is perfectly reasonable. Now, the bottom line is this. As of right now, we don't know what the outcome is going to be, although it looks promising for the January 6 protesters. The Supreme Court's ruling on this case is anticipated to be around July, which would clarify the scope of the federal obstruction law and its applicability to the January 6 protesters, and potentially other similar cases. And so it seems that hope remains for those targeted by the federal government for their actions on the January 6th protest. But whether or not the court rules in their favor, well, is yet to be seen. From the To Be Frank show, I am Adrian, my friends. Thanks for watching. I'll see you all next time.